We want to get started, and I'm Deborah Parks. I teach on the faculty here, and it's my great pleasure to introduce our distinguished visitor to the law school today, Joanna Birenbaum. Joanna is the Director of Litigation from the Women's Legal Education and Action Fund, which is a national organization which has branches and affiliates across the country, including the Manitoba branch here, and we have some members of the LEAF Manitoba branch here, and I want to welcome them to the law school today. Joanna is going to be telling you a little bit about LEAF and its work, as well as particularly focusing on a case that is one of the cases that LEAF is working on right now. But since receiving her law degree from the University of Toronto in 1998, Joanna has had an interesting and varied legal career, and it's one of those things that's nice. It's been a bit of a theme in our Distinguished Visitor Lectures this year. People who've been doing interesting things with their law degree, which is kind of an interesting byproduct of inviting interesting people, is that you get to see that there's lots that you can do with a law degree. And Joanna worked for a number of years on Aboriginal rights litigation, including representing some First Nations here in Manitoba, worked internationally representing groups before the UN human rights monitoring bodies in Geneva and New York, working on issues of race and racism, Aboriginal rights, and equality issues more broadly. And she's only been with LEAF for less than a year. I just was looking back at my notes, and I think you joined November 18th last year. And the amount of work that LEAF has on its docket and that Joanna is responsible for coordinating is quite something. And so it's a real pleasure that she was able to, and an honor for us that she's been able to find some time to come visit us here. I won't take any more time other than just to take a moment to thank the Law Foundation of Manitoba for supporting this event. They support many of our initiatives here at the law school, and they are supporting this distinguished visitor today, as well as our faculty of law. So without any further ado, Joanna Birenbaum.
Thank you very much. It's a real honor and pleasure to be invited to speak at this Distinguished Visitors Series, and thank you to Professor Parks and the Manitoba LEAF folks for facilitating my being here today. And since we're doing all manner of thank yous, it's really important to acknowledge University of Manitoba faculty and students and alumnus for the many hours of hard work and dedication to LEAF over the years, and looking forward to it into the future. Volunteers are the lifeblood of LEAF, so acknowledge your contributions and keep it up. And perhaps we'll have some new volunteers or new lawyers and researchers to welcome into our fold after my talk today. So as Deborah said, I wanted to start out for just 5 minutes or so to tell you a bit about LEAF, who we are, and then I'll get to the topic of the talk today. So LEAF was founded in 1985, which was the year that Section 15, as you know, the equality guarantee of the Charter, came into force. Our mission is to achieve substantive equality for women and girls in Canada. A tall order, we know, but one that is as crucial today as it was almost 25 years ago when we were founded. We work to achieve this goal primarily through three means. One is through litigation, usually intervenor litigation at the appellate levels. Secondly, through law reform efforts. And thirdly, through public education. And I know that there's University of Manitoba students now who are engaged in our education work, particularly with high school students. We've intervened in over 150 cases at various levels of court across the country, but as I say, primarily at appellate courts in the Supreme Court of Canada. And since our first intervention in Andrews, which, as you know, was the first equality rights case to be decided by the Supreme Court, we have been recognized as a leader in the development of charter equality jurisprudence. And in fact, just last week, I was at a symposium on interveners at the University of Toronto Faculty of Law, and one of the presenters at the symposium was former Supreme Court of Canada Justice Iacobucci. And in talking about the role of interveners, he said, with specific reference to LEAF, that the interveners played a formative, and that was his word, and substantial role in the development of charter jurisprudence, particularly in the early years. Central to LEAF's commitment to and our analysis of substantive equality is addressing the ways in which multiple systems of oppression affect women. For example, on the basis of Aboriginal identity, sexual orientation, race, ability, age, religion, and so on. We celebrate our 25th anniversary in April of next year, which is a cause for celebration, but also a cause for renewed focus. It's a celebration because of the very important gains that have been made by LEAF and other feminist activists. But it's also a time for renewed focus because the gains that have been made can't be counted on, and discrimination against women is still a significant component of Canadian society. Really, to put it simply, we've far from made it. And in fact, in 25 years of charter jurisprudence, there has not been not one successful Section 15 sex discrimination case brought by a woman to the Supreme Court of Canada. Not one. Other examples of, current examples of women's inequality and regressive measures which require our vigilance and response are really too many to list, but a few. In March of this year, the federal government gave royal assent to a piece of legislation called the Public Sector Equitable Compensation Act. And that legislation fundamentally erodes the human right of women who work in the public sector to equal pay for work of equal value, to pay equity. In general, as a result of labor market discrimination, the undervaluing of women's caregiving roles, occupational segregation, women overall still only earn 71 cents on the dollar as compared to men. If you're a racialized woman, you earn 68 cents on the dollar as compared to men. And if you're an Aboriginal woman, you earn a staggering 46 cents on the dollar as compared to men. Women still disproportionately suffer the adverse effects of marital or relationship breakdown. In this current economic downturn, pregnant women have reported being terminated or otherwise discriminated against in employment at alarming rates. It's estimated that 83% of women with disabilities will experience sexual abuse in their lifetimes. Human rights protections across the country are under attack, with vocal calls for the eradication of human rights commissions and tribunals. In 2006, the federal government cut a program called the Court Challenges Program, which many of you may be familiar with. It was a program that funded Section 15 test case litigation by marginalized and disadvantaged groups with the purpose of protecting the rule of law, protecting the guarantee of Section 15 in the Charter, and ensuring access to justice for marginalized groups. In a closed-door meeting in September of this year, Prime Minister Harper referred to this program as a program which supported left-wing fringe groups. Left-wing fringe groups. Among those who were funded to litigate their Section 15 charter rights under the program were low-income women, women with disabilities, Aboriginal women, like Sharon McIver, who just recently successfully won a sex discrimination case to the status provisions under the Indian Act. And lastly, even within the legal profession, women continue to face discrimination. And rather than cite more statistics, just two anecdotes. Since being in the position now as the director of litigation at LEAF, I get to hear stories. So just in the last month, women who were doing job interviews for first-year associate positions at large firms, I believe in Toronto, told me that they were asked point blank in their interviews whether or not they intended to have babies in the next 10 years. Another anecdote was a student who was doing articling interviews who said that she, in the end, had to take her wedding ring off when she was doing her interviews to stop the tide of questions about her wedding and about personal matters, as opposed to just asking her about her skills and her interests. So needless to say, the LEAF's work for women's equality remains extremely important, and our work continues to be cutting edge. And lastly, just in terms of an overview of LEAF, we often talk about our mission as being transformative. And what we mean by that is that what we try to do in our interventions and in our law reform work and in our public education work is to try to get the courts and people to see the world differently, to recognize the ways in which structural inequalities exclude some and perpetuate the power and privilege and benefit of others, usually those in dominant society. And so this transformative mission of shifting the debate, of shifting the discussion, brings me to the topic of the talk today, which is the case of NS, the niqab in the courtroom, and litigating for women's equality in a sexual assault case. In NS, LEAF was granted leave to intervene by the Ontario Court of Appeal. The appeal there has not been heard yet. It may not be heard for some time, but sometime in 2010 it will likely be heard. NS involves a sexual assault complainant who is an observant Muslim woman who wears a niqab, which is a head covering which covers the face with the exception of the eyes. The two co-accused are an uncle and a close family friend. They all attend the same mosque together. The accused are charged with allegations of sexual abuse when the complainant was a child, and the charges were laid when the complainant was an adult. The preliminary inquiry commenced in September of 2008, so just over a year ago. And at the beginning of the preliminary inquiry, the accused objected to the complainant wearing the niqab while giving evidence at the preliminary inquiry. And asserting their right to full answer in defense, they claimed a right to demeanor evidence, which in this case means the facial expressions of the complainant from the eyes downward. When the objection was raised, the Crown immediately indicated to the court that this engaged the complainant's charter rights and strongly, and that was the word of the Crown on the transcript, strongly advised the court that the matter should be stood down to permit the complainant to get independent legal advice. The Crown reminded the court that the Crown represents the public interest and doesn't represent the complainant. And in what was a somewhat unusual move, the court decided that it wanted to hear from the complainant without the benefit of independent legal counsel. And so the court asked the complainant to take the stand, but said to the complainant, this is going to be informal, and that was the words of the court. It's informal. I just want to ask you some questions. You're not going to be cross-examined by the Crown or by counsel for the accused. It won't be, again, the words of the court, a matter of giving evidence. And then proceeded to ask the complainant a series of questions about her religious convictions and her reasons for wearing the niqab. And in this discussion with the judge, the complainant made a number of statements, including that she'd been wearing the niqab for the past 5 years, that she had a strong objection, her words were strong or very strong, objection to removing the niqab, that for her it was a matter of honor, a matter of respect, of modesty, and that she did not remove the niqab except in the presence of those that she could not marry, so close family members and women. And perhaps most significantly, she described the veil as a part of me. Then, towards the end of her discussion with the judge, she also said that she would feel more comfortable if in a courtroom full of men if she had her niqab on. The preliminary inquiry then proceeded to other evidence, and the objection was returned at a later date to be argued, during which period the complainant did retain independent legal counsel. When it was brought back to be argued, a fact came out in the course of the argument. The complainant had had a driver's license photo taken with her face exposed, albeit taken behind a screen, out of the view of others, and by a female official. And when the court rendered its judgment on the objection, the court ordered the complainant to remove her niqab. And the basis of the court's reasoning for this order was the court's judgment that the complainant's religious belief was simply not that strong. And that as a result of her belief not being that strong, that her religious convictions shouldn't fetter the rights of the accused to full answer and defense. Now, in making this decision that the complainant's religious beliefs weren't that strong, the judge drew an adverse inference from her use of the word comfortable, despite the assurances that her discussion with the judge would not be a matter of evidence. And the judge drew an adverse inference from this driver's license photo, which the complainant did not give any evidence with respect to and was not given the opportunity to explain it. And finding that the photograph was inconsistent with her belief in keeping the niqab on in the courtroom. And just to explain before I go on to what happened next, the court essentially made at least 3 errors of law in its ruling. The first was an error of law in terms of denying her the procedural justice, in the sense of denying her independent legal counsel, and then compounding that by prejudicially relying on the evidence or statements that she gave without the benefit of counsel. Secondly, the court should not have assessed the strength of her religious conviction. The charter jurisprudence at the Supreme Court in Anselm, in a case called Mutani, and most recently in a case that was decided this year, brought by the Hadarin Brethren in Alberta, the Supreme Court has made very clear that a claimant need only establish that a religious belief is sincerely held, and that it is not for the court to probe into the depth or the strength of that belief. And lastly, the court balanced the charter values and the charter rights of the accused and the complainant, and the preliminary inquiry judge has no jurisdiction to make charter determinations or to balance charter principles. And that's significant in terms of the procedure for dealing with the niqab, which I'll discuss a bit later. So following this order that she be required to remove the niqab as a precondition to giving evidence, the complainant then commenced an application to the Ontario Superior Court of Justice asking for 2 things. First, she asked for an order quashing the order of the preliminary inquiry judge that she remove the niqab, and secondly, she asked for a Section 24(1) charter declaration that she be entitled to wear the niqab while giving evidence both at the preliminary inquiry and at trial. That application was heard in, I believe, March of this year, and the decision was rendered at the end of April. And what the court ordered was that it did quash the order of the preliminary inquiry judge requiring her to remove the niqab, but the court refused or did not order that or make a declaration that the complainant was entitled to wear the niqab while giving evidence both at the prelim and at trial. And instead, the court sent the objection back to the preliminary inquiry court, the same preliminary inquiry judge, with directions as to how this objection to the niqab should be dealt with both at the prelim and at trial. And I'll explain what those directions were a bit later. The complainant is now appealing that decision to the Ontario Court of Appeal. There's 5 interveners thus far who've been granted leave to intervene in the case, which is really quite a lot for an appellate, provincial appellate as opposed to Supreme Court of Canada appeal. The interveners, in addition to LEAF, are the Muslim Canadian Congress, the Canadian Civil Liberties Association, the Criminal Lawyers Association, and the Ontario Human Rights Commission. The FACTA of all of the parties haven't been filed yet, but it is almost certain that LEAF will be the only intervener that will focus on the gendered and racial inequalities which are at the heart of the case. And so what do I mean by the gendered and racial inequalities that are at the heart of this case? Well, what's significant is that in the case to date, the court, the media, and even the Human Rights Commission have essentially presented this case as involving a tension between the complainant's rights to freedom of religion and the accused's rights to full answer and defense. And in Leaf's view, this almost exclusive focus on freedom of religion has obscured an essential aspect of the case. The religion versus fair trial dichotomy doesn't adequately address the particular inequalities raised when an observant, niqab-wearing Muslim sexual assault complainant is ordered to remove her niqab at the behest of two co-accused. This dichotomy abstracts the accused's objection to the niqab from the sexual assault context in which the objection is raised. The primary focus on freedom of religion, in our view, fails to adequately consider and give weight to the Section 7, security of the person, and Section 15, equality rights of the complainant. And so with that overview of Leaf's analysis, I want to elaborate on four key concerns or equality issues engaged. And I want to do that by asking four questions in response to the objection to the niqab. And so the first question is, to what extent is the accused's objection to the niqab simply a tactic to whack the complainant? From an equality perspective, the accused's demand for an order requiring the complainant to remove the niqab must be situated within the ongoing history of legal and procedural norms which re-victimize sexual assault complainants. These norms are driven by sexist, racist, classist, ableist, and other stereotypes or rape mythologies that deem certain women, such as racialized women, prostitutes, poor women, Aboriginal women, as unrapeable, less innocent, less believable, more likely to have consented, more sexually available. Rape continues to be scripted in court in racial terms, with the ideal rape victim still being white, middle class, sexually and morally virtuous, and unprovocative. Persisting rape mythologies also include that women are more likely to lie or exaggerate about sexual assault, fantasize about rape, or be deluded or hysterical in their allegations. Now, some legislative reforms have been achieved, largely a result of feminist activism by Leaf and by others, which restrict access to complainants' therapeutic records to sexual evidence of sexual history and evidence of sexual reputation. But these statutory reforms have only partially limited the abuse of complainants in the courtroom. Sexual assault complainants continue to be subjected to greater scrutiny than any other category of witness. Women continue to be aggressively cross-examined, including on their medical records, including on their sexual history, in order to exploit rape mythologies, humiliate them, and shatter their credibility. A decade ago, the Supreme Court of Canada very clearly denounced defense tactics intended to whack the complainant, and that language is the Supreme Court's language. But despite legislative reforms and despite the court's denunciation of such tactics to humiliate and harass complainants, these tactics have not been eradicated and remain a central feature in the sexual assault trial. So the first question in response to the accused's objection to the niqab in the courtroom is not how do you balance the freedom of religion of the complainant as against the fair trial rights of the accused. Rather, the first question is, to what extent is the objection being lodged specifically to humiliate and exploit the complainant? And to whack the complainant in a very particular way that is damaging to her as an observant Muslim woman who wears the niqab. To what extent is this objection really about fair trial rights at all? The second question, this is a related question, is what would be the effect of an order to remove the niqab on the complainant personally and on the group of minority group of niqab-wearing women more generally in Canada? So as I've said, the complainants described the niqab as being a part of me. So the accused are asking the court to strip this complainant of an item of religious dress. In this case, the metaphors of re-victimization, of stripping, of laying bare, of undressing, of sexual assault complainants through harassing, cross-examination, and other aggressive tactics become literal. The complainant would literally be ordered to undress as a precondition to giving evidence. And the concern is that such an order would constitute a form of state-imposed psychological trauma and harm in contravention of the complainant's Section 7 charter rights. The Section 7 rights of the complainant also come into play in a way articulated in the complainant's factum by her counsel. So this was in the factum submitted to the Ontario Superior Court of Justice by her lawyer. But in that factum, her counsel notes that in order to remove the niqab would deprive the complainant of an important form of solace, which may be deeply meaningful and important to her as a victim of sexual assault. Her deprival of a religious practice in this context engages not only her freedom of religion, but also her Section 7 charter rights, since she's being forced to choose between her religious practices and beliefs and access to justice. Secondly, if niqab-wearing women risk having to remove their niqabs in court, or if they risk being subjected to burdensome and onerous procedures to justify the wearing of the niqab in court, to what extent will this exacerbate the already extreme underreporting of sexual assault by this stigmatized minority group of women? As it is, just generally, less than 6% of sexual assaults get reported, and even fewer of them are prosecuted. In order that the niqab be removed in the courtroom, in sexual assault trials will effectively shut out niqab-wearing women from the criminal justice system. The message essentially will be that they can be raped with impunity. The implications of such an order would extend beyond simply the sexual assault trial. If niqab-wearing women believe or are led to believe that they'll be required to remove their niqabs in court, or they'll be subjected to onerous or burdensome procedures to justify their niqabs, it's unlikely that they would access the criminal justice system for resolution of any dispute, whether it be immigration, family, contract, or other forms of disputes. So the heightened risk of physical harm from an order to remove the niqab and the resulting barrier to access to justice engages the Section 7 rights of the complainant as well. In our view, the need to create a respectful and accessible space for niqab-wearing women in the courtroom is significant for advancing their equality rights and their equal participation in Canadian society. Whatever one's views are on the niqab, effectively disenfranchising women who wear the niqab is not going to promote their equality. Third question. What are the broader social and political implications of our Court of Appeal ordering a niqab-wearing woman in a sexual assault trial to remove her niqab? The political implications can't be ignored. In our particular post-9/11 moment in history, Islam has come to mean more than religion. Muslim has become a stand-in for irrational, backward, extreme, even terrorist. Muslim has been constructed as race, as contrasted with Western society's perceptions of itself as rational, civilized, and secular. The niqab has become a symbol of this clash or supposed clash of civilizations, and it's presented as a threat to what is seen as modern secular society. So in this context, in the context of this political reality, to what extent would an order that the complainant remove her niqab be or be seen as an enactment of racial and cultural superiority over the Muslim minority, a forced unveiling to bring Muslim women into modernity in the very troubling context of effectively undressing this sexual assault complainant? Question 4. And this is a series of questions. What is the probative value of demeanor evidence? Or conversely, to what extent does demeanor evidence subvert as opposed to advance the truth-seeking function of the criminal trial? what are the accused really asserting when they say they have a right to demeanor evidence? And how have assessments of demeanor been informed by racist and sexist rape mythologies? How does the perceived need to see the victim's face in fact stem from or play into rape mythologies about how a real rape complainant or a real rape victim ought to appear, react, emote, and so on? And these questions are particularly potent when these mythologies penalize women who don't fit the typecast of the ideal rape victim who is white and middle class. And I'm sure you can infer from the questions that I'm asking that Leaf's concern is that demeanor evidence in the sexual assault context has often perpetuated and reinforced discrimination and inequality and has subverted the truth-seeking function of the criminal trial. But with looking now at the complainant's rights to full answer and defense, I mean, what is the law on the scope of these rights? And the Supreme Court of Canada has said very clearly that there is no absolute right to see the face of your accuser. The court has also said very clearly that the fair trial rights guaranteed by Section 7 and 11D of the Charter are not a license to exploit any technique of cross-examination that would be useful to the accused, nor is there a right to glower at, intimidate it, or stare down a witness. Those are simply not rights that are guaranteed by Section 7 and 11D. So in this case, the accused need to establish that the demeanor evidence that they're seeking actually has probative value. And what's really interesting is that despite the deep attachment in our legal culture to the importance of demeanor, the reliability of such evidence is increasingly coming under question, both by the judiciary and by social scientists. And a very interesting study or series of studies was done by a professor, his name's Paul Ekman at the University of California, where he studied those who are in the profession or assumingly in the profession of determining whether or not someone is lying or telling the truth. And so he studied judges, lawyers, police, FBI, CIA, Secret Service, military services, polygraphers, and so on. And what was incredibly revealing about his results is that no one in any of these categories of profession did any better than chance in spotting a liar based on demeanor. The judiciary is also, in Canada, has often pronounced on the limitations of demeanor evidence, and standard or model jury instructions all warn juries about placing too much reliance on appearances, usually giving particular attention to just how unique and stressful an experience it is to be a witness, never mind a sexual assault witness, but to be a witness altogether. Other factors which undermine the reliability of demeanor evidence include cultural differences, power imbalances, social differences, and other differences between lawyers, judges, and witnesses in the courtroom. And misuse of demeanor is not limited to sexual assault complainants or to complainants or victims of crime more generally. Discriminatory judgment based on demeanor have had devastating consequences for accused as well. Two examples would be Guy Palmerin and Susan Nellis, cases of wrongful convictions or wrongful charging. So Leaf's view is that the very limited probative value of demeanor evidence in the sexual assault and cross-cultural contexts and their routine misuse in these contexts means that the right to full answer and defense will rarely, if ever, be engaged by a complainant in a sexual assault trial wearing her niqab. And this is even more true at the preliminary inquiry, where the court has no jurisdiction to assess credibility. And in my informal discussions with counsel about this case of practicing lawyers, my experience has been that the strongest objection to Leaf's arguments have been about the value of demeanor evidence. And so I just want to be clear that we acknowledge the deeply held beliefs that people have that one can access useful information from seeing someone's face. But what we're questioning and what we're asking counsel and others to question themselves is that deeply held belief actually right? The empirical evidence strongly supports the Ontario Court of Appeals adage that lawyers and judges do not have divine insight into the hearts and minds of witnesses. The hard work now is to bridge the gap between what we rationally know and understand to be the limits of demeanor evidence and the legal culture's instinctive resistance to placing less emphasis on demeanor in this case. I was going to talk about the procedures, but maybe leave that for questions. Do you want me to leave 10 minutes? Okay, so the last comment that I want to make about the case, and maybe talk to me at lunch about what procedures were ordered by the court and what the equality concerns are with those procedures, is that in this case the accused have elected to be tried by judge and jury. And so the discussion is centered, even in my talk today, on the accused's right to full answer and defense and what the limits on those rights are and whether the niqab impinges on those rights. But the irony is that the real prejudice at trial will almost certainly be suffered by the complainant herself if she's wearing a niqab. A niqab-wearing witness risks activating the prejudices, or at a minimum the discomfort, of jurors, and she risks as a result not being believed. And she must be hiding something. She must not be telling the truth if she's wearing a niqab. So, in the end, arguably the biggest challenge to the criminal procedure's quest for truth in this case will be ensuring that the jury overcomes the discriminatory barriers to the niqab to ensure that the complainant, in this case, actually has a chance of being heard and has a chance of being believed. Leaf's role as an intervener in this case is an important one. Our contribution will be to present these arguments and to present this complainant and her rights in their full complexity, to draw out the gendered racism, which I've touched on in this talk, and to ask the court to carefully recognize and consider the interconnected and intersecting inequalities which this case presents to it. Thanks. Sure. In the media discussions about this case, there's been a lot of controversy about the veil and its doctrinal support. That's not Leaf's interest in this case. Leaf's concern is the treatment specifically of a sexual assault complainant. So, which is not to say that your question isn't an important one, but it's not one that is Leaf's focus in this case. And in terms of the doctrinal support, I mean, the question before the court in this case is only whether or not this complainant has a sincerely held belief in the niqab. That's the threshold that needs to be met. It's not a high threshold. And the court is not going to be interested in getting into, I don't think, in getting into a religious debate about whether or not there's adequate support in the religious doctrine for the wearing of the niqab. But I agree with you that that's a question that's going to continue to be asked. I think that's a really interesting question. And I'm not sure. I'm not sure that I can answer it. Certainly, assessments of credibility are going to continue to be part of the justice system. And what our concern is that those assessments be made with full attention to the prejudices and biases which judges and lawyers bring to those assessments. But it's an interesting question that you raise. Sure. Well, what's interesting about that question, which I hadn't included in my talk just because there wasn't time, is that originally the accused were not challenging the sincerity of the complainant's belief. All that they were going to challenge was its impact on their rights to assess demeanor evidence. And on the first day of the preliminary inquiry, when the objection was made, they took the position that they weren't challenging the sincerity of the belief. Then there was a conversation with that a police officer had with the complainant in which she described her reasons for wearing the niqab. This was communicated to counsel for the accused, and when the preliminary inquiry resumed, they resiled from their position that they were not going to challenge the sincerity of the religious belief, and they put that, they included that in their objection. So that doesn't answer your question, but it provides even additional context. And I can't say that we know what role was played in this case, but you can draw inferences from what did happen at the preliminary inquiry. That's very interesting. The complainant's counsel, from what I saw in their factum, have not made that point yet, but that's an interesting one. I mean, another part of the background context of this case is that the complainant did report the assaults when she was a child. She reported them to a teacher, and the father, it's not clear from, the information I have about this case is what's on the record. But the father somehow convinced the police not to lay charges, and then she went to the police and had the charges laid when she was an adult. That's right.
How did the justice system handle this niqab-wearing judge sitting?
That's a good question. I mean, another one of the questions like that this case triggers is, well, if it's so important to see the face of a witness, does that mean we can't have blind lawyers? Does that mean we can't have blind judges? Does that mean that people who have a form of facial paralysis or have been terribly burned by a fire or some other kind of accident, that they can't be witnesses because you can't assess their demeanor for various reasons? So there's a whole stream of questions like that which which give depth to the analysis of this case. I wanted maybe just to use the last 2 minutes. I know that I said that I would talk about the procedures, but maybe I should just talk a bit about what LEAF is doing. Should I do that? 1 minute. Oh, is that it? Oh, I see. Okay. Well, LEAF was at the Federal Court of Appeal last month in a case called Mi'kmaq Nation of Gaspé, and our role there was to assist in ensuring that Section 15.2, the affirmative action guarantee in the Charter, or the protection of affirmative action programs under Section 15 of the Charter, was applied and analyzed in a way that would actually protect the rights of marginalized groups. You can ask more questions about that after. And at the end of this month, we are seeking leave to intervene in a case at the Supreme Court of Canada called Whitler versus Canada, which is an age discrimination case, which has particular impact on elderly women, and which our submission will be that the discrimination at issue in that case reflects the view in society that elderly women don't matter, their needs don't matter, and that their needs and circumstances are not as valuable or as worthy of consideration and respect. There's a number of big constitutional challenges which LEAF is monitoring and developing our responses to. One is in relation to the criminal prohibition of prostitution-related activities in Ontario. A Section 7 charter challenge to those provisions was heard in October. The argument finished in October, and the decision will probably come down sometime in 2010. And LEAF's analysis, which we are developing, as I say, will be from a Section 15 substantive equality perspective. In British Columbia, the Attorney General has referred the constitutionality of the criminal prohibition of polygamy to the British Columbia Supreme Court as a reference. And so we're developing our position in response to that. And I'm probably out of my 1 minute, but there's lots more. So please do come talk to me after talk. Thank you.